Well, very good. Well, we're ready for our second panel. Our second panel is Perspectives of Providers and Regulators. And this panel has chosen to work as a panel rather than as from the podium. And we're going to start off with Paul Gordon, then who is an attorney and also who's the author of a book on senior housing and care facilities, which is right there on my desk. It's an excellent book, I can say, and I'm going to be using it a great deal in the future. Really, very good. In addition, we have in the center Eric Dowdy, who's Vice President of Policy for Leading Age California. Leading Age, and also it's called, the other name for it?
Just Leading Age California.
Okay, it's okay, just
Yes.
Leading Age California. It used to have another name, I know. And so really this is the organization that is the kind of parent organization to CCRCs and senior care in California and nationwide. And then first on your agenda, but last to speak on this panel, will be Robert Thompson from California's Department of Social Services and the Long-Term Care's CCRC division of that unit. Okay, let's let you go, gentlemen.
Okay, I'm going to start off, and just first of all, I want to say how pleased I am to be here, and I think it's really healthy to have this kind of a discussion, and among residents, providers, regulators, and anyone else who's interested in it. This is a great forum, and this sort of thing doesn't happen very often, so thanks for setting it up, Catherine, and everyone else who is involved. I've worked with the CCRCs, represented providers of CCRCs, for about more than 35 years. And so I've seen a lot of the evolution in the field and in the regulations and so forth. You know, as a lawyer, you see the regulations, and sometimes maybe you see the 2% of the time or whatever it is when things go badly, and then you go back and try to change the policies or change the contracts to help avoid that sort of thing in the future. And sometimes the laws get changed or regulations, as the case may be for the licensing statutes and regs. But the bottom line is, I think that the contracts, particularly the law, is always catching up with reality. Reality is always a little bit ahead of the laws and the regulations. And what people actually do in these communities, the providers, what they actually do is more than what the regulations require them to do. And it's more often than what the contracts require them to do. And I think I liked a lot of what I heard in the prior session, because there was, from the residents, because there's an acknowledgement of that. You know, there was an acknowledgement that the services were delivered and there's satisfaction. There was an acknowledgement that that if a resident is on the board of the organization, voting or non-voting, it doesn't matter. There's a responsibility to be thinking about the interests of the organization as a whole, as opposed to one's personal interest. I'll give an example of that. We've had some disputes that I've been involved in with residents, and where I represented the retirement community, where the residents were saying, we shouldn't use monthly fee revenue to repair the roof. Well, why not? Because the future residents and their entrance fees ought to be used to pay for the roof, because the roof is a capital item, and entrance fees should only be used for capital items, and monthly fees should only be used for services that are delivered to me while I'm alive. Well, you could agree or disagree about what's right or wrong and what the contract says, but the bottom line is, residents have a perspective, and the perspective is their own life, their own time at the community, and they may not be as interested in the future long-term health of the organization for the long term. And it was great to hear from residents who have thought about this, the acknowledgement that you have to be thinking about the long-term viability of the organization. In terms of the scope of what's available in the marketplace, one of the things that's changed, and for me, what I've seen change, is a huge increase in the diversity, the complexity of what's available. When I started out in this field, most everybody had the same kind of program. You know, it was an entrance fee that amortized down to zero refund over 3 to 7 years, period. That was it. It was 100% not-for-profit. And most of the providers were providing type A, fully insured medical benefit type contracts. What's changed in the meantime? A whole lot. There's nonprofits, and I've worked with every one of these folks. There's nonprofits, there's for-profits, there's fully amortized entrance fees, there's 90% refundable fees, 50% refundable fees, 75% refundable fees, 25% refundable, I mean, every kind of variation you can think of. There are condominiums. I have a client where every single member of the board is a resident, every one. They 100% govern their CCRC. Condominiums, there's cooperatives. I mean, we can get into, it is now illegal for a homeowners association to be the provider. That was a decision of the Department of the Legislature. And we can get into the reasons for that.
I'll add that one that should be revisited, a decision that I'm sure the department played a leading role in making because of difficulties that it had with that particular model. But that was in that market. And at that time, under that regime of statutes. Now, as Paul has said, much has changed. And that change was in about the early 90s. The fact is that there is a similar model which has operated quite effectively in Marin, of course, which leads the argument toward a reevaluation of whether residents themselves can run their own continuing care retirement community. It does present issues along the lines that Paul raised earlier about, well, is the proper focus for the operation on a long-term basis going to be present? Well, it seems that it very well can be. And that in today's market, a resident-driven provider organization could survive quite easily given the different forms that the product can take. Forms that were never even contemplated back at the time when the decision was made to eliminate the prospect of a resident-driven operation. So now it can. I think that
one of the things, you know, there was discussion earlier about the paternalistic type of approach to residents' rights. And one of my conclusions at the time when it was determined that homeowners could not be continuing care providers under the statute was that if the Department of Social Services, whose job is to protect the residents from the provider's misdeeds, let's say, or failure to abide by the regulations. But I mean, if one of the purposes is consumer protection, and the licensee is composed 100% of consumers, then how do you enforce a law that's designed to protect people against the people who are supposed to be protected by the law? That was one of the dilemmas, I think, with the whole idea of there being a licensing and an oversight process to protect consumers from what they are, you know, doing to themselves, if you will, as operators of the continuing care retirement community. And I think that little dilemma still exists. And I would say on the issue of residents on the board, and this goes way back to the fact that the revenue ruling that was mentioned, the IRS revenue ruling 72-124, which somebody in my firm, Tom Jenkins, was able to get from the IRS in 1972, 3 years before I joined my firm. The reason he was able to get that was this is market rate housing and services for the elderly, so-called. And in those days, the market rate housing and services is not a tax-exempt activity. So how do you get a tax exemption for market rate housing and services to a population? You get it by convincing the IRS that it is that the elderly are a distressed class of people who need the care. You know, I'm not making this stuff up. It's read the ruling and you will see that it's the truth. that it's a distressed class of elderly, and that's how you get the tax exemption, which includes an income tax exemption. In California, you get a property tax exemption, and guess what? Residents benefit from all of this. You know, if you don't, if you're in a for-profit community, and there are many very nice for-profit communities that are, you know, they're doing very well, and the residents are happy, I would say, for the most part, as much as in anywhere. You know, there are shareholders who are making a profit. There are taxes being paid on the real property. There's taxes being paid on the income, and you know, and the same level of service. Somebody's going to pay for that. Who's paying for it? The residents are paying for it. So the fact that 85% of CCRCs, give or take, are not for profit is part of its historical, and it's certainly based on this revenue ruling. Now, on the point of monthly service fees going up, one thing I liked from the prior session was everybody wants the same thing ultimately, and the question is how to get there, and that is success. There's no not-for-profit CCRC that wants to raise monthly fees to the point where they become unaffordable. Nobody wants that. Why? Because number one, you want to stay in business, you want to be able to fill the vacant unit. It's in everybody's interest to do that. Number two, not-for-profit CCRCs have an obligation to care for people who run out of funds to the extent they're able to do it. So you don't want to force somebody into having to, you know, dip into the fund for a monthly fee subsidy. I'm going to stop for a minute, let somebody else talk.
I would just add on the resident and the board of directors issue. Leading Age California doesn't have a position on that, but we have been working with CalCRA, and I know that many of our members do have resident board members. Our concern is the conflict in the California Corporations Code, where there is that fiduciary responsibility, and I know that's been addressed in many instances. So we're continuing to work with CalCRA on that, and I think it will have a position when the bill is actually introduced. But just for all of you who are wondering what our position is as we don't have one and we're still looking at it. So
I want to try and tie up one common theme that relates to the competition between the resident's perspective and the provider's perspective. And the example was raised in terms of the use of a monthly service fee revenue for capital expenditure. And also that ties into the indictment that the residents make that the department isn't properly performing its financial oversight function. And the reality is that that indictment is misplaced. As Buzz Gittleson mentioned, basically you're finding deficit in the department's performance by finding that it hasn't done what the statutes don't enable or authorize it to do. So in order to evaluate what the department is actually doing in terms of its financial monitoring, I won't say oversight, but monitoring of the performance of providers, you have to look to the authority which is conveyed to the department through the statutes. And let me say right at the outset that when you examine the statutes from that perspective, you'll find that there is no regulation of pricing. There's no regulation of entrance fees. There's no regulation of monthly service fees or monthly care fees. There's no regulation as to either of those revenues are collected or how they're used. In fact, let me make that even more clear by suggesting that the models used by different providers vary so extremely that it proves my point. Some providers, judging their market demographics, decide that they can't enter the marketplace with a high entrance fee. The local real estate simply won't sustain the types of entrance fees that continuing care providers are used to collecting. So what do? They reduce their entrance fees so that they can appeal to the market, which is generally within an 8-mile radius of the facility, so that those residents, when they sell their home, are capable of making the entrance fee payment that's required. Well, they still have to collect sufficient revenues to meet expenses, and how are they going to do that? Well, their only other revenue source is that monthly care fee. And many residents may have a portfolio or fixed income supply that will enable them to meet those demands, those capital demands. So the point I'm making is that in one market, you're going to have a provider that offers a product at a low entrance fee with higher monthly care fees. And in another market, like maybe the Bay Area, those entrance fees are quite steep because seniors are able to sell their houses to make that payment, while the monthly care fees are not so high. The fact is that both those providers exist in this market, in California's market. And the reason they do is because the statutes do not contend with pricing structure.
The one area where there is price control, if you will, is on increases in monthly fees based on projected costs. And I realize projected cost is a very wide open thing, but you can't decide. When people ask me about that, clients ask me about that, what I tell them is, how does that restrict you? I think it restricts you in the sense of saying that, if our profit margin is X, under the current situation, all other things being equal, all costs and projected costs being equal, and we want to just increase our profit margin by 50%, you can't do that. It has to be tied to some actual or projected operational cost. Now, what would be a projected operational cost that is not necessary? What would that include? It could include reserves, I think. Yeah, you can correct me if I'm wrong, but I think I know. It wouldn't be the first time. And reserves. And sometimes I think if you need to have a better cash flow position or a better cash position in order to increase your bond rating and to be able to borrow for your next project at a lower interest rate, and your advisors are telling you you need to retain more cash or have more cash on your balance sheet or some such thing, that I think is something that could be rolled into a projected cost. Some of this is going to get into the issue which was raised earlier by the residents of the standalone facility versus the multi-facility. And let me just say, without taking a breath, one thing about that, and that is that I think it's generally recognized, it was mentioned in the earlier session, that there is something like strength in numbers. I mean, you can't generalize or point to individual properties and say that this is universally true, but lenders looking at CCRCs or groups of CCRCs take more comfort in seeing a group, and they want a cross-default provision whenever they're lending so that everybody in the group is tied into the financing, and all of the properties are liable to perform the latest iteration of financing, which may only go to benefit one of the properties, but everybody's on the hook and you get a better rate. You can borrow at a better rate when you do that. Whereas if you're a standalone and you don't have that kind of strength in numbers, you don't have the economies of scale, it's going to cost you more to borrow money. The other thing is the historical perspective, which is, sometimes you'll hear the people at the newer communities complain that they're paying for the upkeep of the older communities that were built 50 years ago. Well, it's just as easy for the people in the older communities to say, look, the reason there even is a new community is that this company has built its credit on 50 years of operations of the 5 or 6 or 10 or however many communities are already out there, which gives us the capability to even borrow the money to build your new community and to do it at a rate that helps keep the cost of operation down.
All good points, and Paul knows that he's pretty safe with most of these statements because he's promoted contracts which include those provisions that have been approved by the department. So unless he wants to catch me in a gotcha, everything he said is true. And it does raise some issues in terms of the statutes, unfortunately. The statutes speak in only one provision in terms of restrictions or limitations, if you will, on monthly care fees. And that's in a provision that addresses the requirements of continuing care contracts. So the continuing care contract includes a provision that says monthly care fee increases shall be based on prior per capita costs, projected costs, and economic indicators. The provider complies with the statutes. There's no other provision in the statutes that says if the provider fails to measure increases in costs on these three factors, they're in violation. So if they do violate that provision, while there is no commensurate violation of the statutes, there is possibly a breach of contract. But again, the bottom line is that the department doesn't regulate fees. It just does not. There's no authority in the statutes that would address that kind of action by the department. Now, that having been said, let me just say something else. That when you look at the, let's say, limitation on the monthly care fee increases that we just discussed, it's very difficult, as Paul suggested, to apply that to the two different scenarios that Paul raised. Think about that for a second. One is where the provider is a standalone operator, and the other is where the provider is a multi-facility operator. Let's make it even more complicated. You have a multi-activity, multi-facility provider. You've got a provider that not only operates multiple CCRCs, but one that's operating low-income housing and a few skilled nursing facilities out there. The statutes don't regulate CCRCs. They regulate providers. And the provision we're talking about addresses the provider's projected costs. Well, right away you've got an ambiguity that is subject to exploitation that could be used to raise fees based on the provider's other activities and the inability of those activities to be self-funding. There are occasional losses, which have to be funded from somewhere, and it could be the CCRC. When we look at a provider's audited financials, we're looking at the provider's ability to perform its continuing care obligations. And the bottom line is it comes from the provider's overall financial health. If the provider's CCRC is doing wonderfully, but its financials show that all its other operations have deteriorated its overall financial condition to one that's in terrible distress, we have a problem. Conversely, if the provider's doing wonderfully in all of its other activities, but its CCRC is under-revenued, not covering its expenses, we're not so concerned. Providers are going to have to basically underwrite those losses, and many do. Many do on a charitable basis. I shouldn't say many. There aren't many that aren't doing well. So, things are getting complicated. And what's the point of this discussion? Really what I'm suggesting is that there's a nuance in the statutes that on first blush doesn't appear to be much of a problem. It does suggest, however, that the department does have some regulatory control over monthly services, which it doesn't, and that should be clarified in the statutes. But more importantly, the application of that provision in the two contexts that are so totally different that the end result is completely different should also be clarified. And I'm leading into my pitch right now, but we're under the we're in the process of attempting to do what is done once a decade, and that is to comprehensively re-examine our continuing care statutes in order to modernize them, update them to contemplate not only today's market environment, but the next decade's environment. We did it in 1990. I didn't do it. Paul probably was around. I'm sure he was around. He's the grandfather of continuing care. I'm the younger nephew. But I was definitely present in 2000. And I acted as the bridge between the various stakeholder groups we had represented around the table and wrote the provisions. It's time again to update our statutes and in several different respects. And then finally, I'll run one more distance here. The revision process has to contemplate three different concerns that are rampant and under-addressed in the statutes. The first is the financial stability of the provider. What is it that the statutes can do to protect residents from the long-term failure of their provider? That seems to me to be the #1 concern of today's residents. The long-term financial stability of their provider. The second is monthly care fees, of course. Monthly care fees, but that plays into that first one, long-term viability. The second aspect that the statutes need to be dramatically updated in terms of is resident involvement. Residents, as we heard in the first panel, have become far more active, far more interested, far more impatient with improper treatment or inappropriate treatment. These are residents that are active, knowledgeable, many experts in their fields during their careers. They're not simply going to move into a place where they're just going to be taken care of. They want to take care of themselves. They want to participate. They want to have an active role. So that needs to be updated. And then finally, the overall foundation of the statutes, the underlying fundamental premises which run through the statutes need to be updated as well. I've got plenty of ideas on that, but that's beyond the reach of this conversation. We are engaged in those conversations now. The department is discussing the prospect of statutory changes with providers and their representatives, as well as with residents and their representatives. And the intent is basically to modernize the infrastructure of the statutes to contemplate what is currently in the marketplace, and then hopefully to foresee what is coming down the road in the next 10 years. I hope that'll have everyone's support. But that is underway, that is in process. And everything that's been said here today has basically underscored the need for the very thing that I'm suggesting. I think we've expired our time. Our 30-minute allocation of conversation.
Excellent start. Well, let's open it up to the audience. Questions from the audience. Ms. Sundry?
Are there any other states that are doing a better job than California?
Are there any other states that are doing a better job than California is the question.
I'll take
Okay.
No, go ahead, Paul.
Well, I am not in a position to evaluate how all of the states are doing, but I will say this. I have read and summarized and compared and contrasted the laws of all 38 states who have legislation in this area. And I was involved, as Catherine was, in the GAO, Government Accountability Office, study of CCRCs nationwide, and it had conducted interviews with them, or they conducted interviews with me and with various clients and so forth. And I think that it is absolutely correct that California has one of the most rigorous statutes in the country in terms of conditions that are put on providers. We had a big bankruptcy in the 1970s, the Pacific Homes case, and that caused a great deal of concern and a back to the drawing boards look at the statutes. And I think the statutes were really revamped at that time to become much more focused on the financial health of CCRCs. I mean, if you think about it, what other industry has this kind of financial regulation? This is a combination of housing, it's a combination of health services, and a combination of hotel type services. Do hotels need anybody's permission to start building a building? Do real estate developers need any kind of permission in terms of, who's signed up and submit your financial plans to a state or a local agency to show that you're going to be financially successful? No, you take your risk, you go out there and you win or lose. And I've worked with a number of people who've gotten into the CCRC industry whose prior experience was only as real estate developers. And they look at these regulations and they go, oh my God, I can't do this. I won't do this. I'd rather go just build something else, office buildings and shopping centers and whatever else. And then some do it, and they've actually, some have been quite successful at it. But the point is, it's a very heavily regulated industry. It's become more and more so, I think, over the years. There have been a lot of amendments over the last, say, 10 years that I think almost all of which were focused on residents' rights. And by and large, you know, I think it's good. The contracts used to be, you know, the shortest continuing care contract I've ever seen was a half a page long. A half of one piece of paper. It had a $50,000 entrance fee and a 50-year amortization period, life care, a half a page. I'm not kidding. Now they're running, you know, 40 pages and with 30 pages of appendices. Yeah. And why? Disclosure. You want transparency? You got it. But it's hard to slog through all of that stuff. And believe me, it's hard to write it too. I spend a long time trying to write those things and trying to stay clear and make it accessible. Anyway, I've gone
You get
off
to write it, I
topic.
have to read it.
Yeah. Yeah.
The question looked to comparative review of how California is doing. And I think I can say unequivocally that in 2000 to 2005, we were at the forefront, the cutting edge across the country. Everyone was looking to us as they were encountering problems and looking to how they might be resolved. I still think that we're as far advanced as any other jurisdiction in terms of protecting the consumers and continuing care. Does that mean much though? No. It means other jurisdictions may be lacking. We, at the same time as we're proud of the position that we're in with our statutes, recognize that they have numerous deficiencies and that there are interests now that have evolved, that have been more sophisticated than ever before, that demand certain changes be made. And I got to tell you that I'm a little bit tired of, over the last 10 years, every time there's a problem, we have a substantial amendment to the statutes. The last several amendments have been basically incident-oriented. And what that means to me is that we lack the foresight to properly legislate and regulate in the manner that probably would have been best for the residents or even the provider's long-term viability. So, for example, we had a facility closure because economically it simply was not sustainable. And the provider made a rational business decision to close the facility. Well, that facility was simply not subject to rehabilitation. It was in a poor area, it had maybe 30% occupancy, and the provider had a foundation and was underwriting the losses on a charitable basis, which was laudatory. But it wasn't business-wise. And at some point, they decided it was not possible to rehabilitate this project, turn it around, make investments, and make those investments pay off, so we need to close it. Well, there was displacement. It was not comfortable. The department had not been involved in anything like that before, so the statutes really hadn't addressed the department's role. We improvised. And of course, the Residents Association was concerned that residents hadn't necessarily received the treatment they would have preferred in the closing of the facility and the relocation process. And there were lawsuits filed and so forth. So immediately we had an amendment to the continuing care statutes related to facility closings. Excellent legislation. A reasonable concept. Really, what happens if a facility needs to close? How do you protect the protectable interest under the statutes, the residents? Well, that just hadn't been contemplated. It took an incident. Similarly, we have, before the capital markets collapse, we had an era of expansion and rehabilitation. You had providers making substantial construction improvements to existing facilities that really worked a hardship on existing residents. They had to live basically in a construction zone. Some were earthquake retrofits, others were simply updating in order to remain marketable. Necessary changes always with the approval of the department, since the department's view is always long-term. Well, that worked a hardship on residents that had not been contemplated before. So, we saw legislation that amended the statutes to provide for temporary relocation and remedies to residents who are relocated from their units as a result of a construction type project for a period of 18 months or longer. And that's reasonable. There are other incidents right now that we can foresee that need to be addressed by the statutes. And as a result, we'd like to do that before those incidents occur. And that's why we're undertaking the process we are now during the course of next year to try and remedy those situations. Anyway, the answer to your question is that California statutes are still the most muscular out there. And I can say that categorically because I review those statutes elsewhere, always hunting for new ideas and possible improvements.
Are you in communication with other regulators in the other states? Do you ever get together and meet or have a phone conference or anything?
We used to do that, but we don't do that any longer. Resources have been scarce. And that's true with all governments. And the notion of getting regulators together just has basically gone by the by. I do have contacts in other jurisdictions. Generally, they're lawyers or branch chiefs or managers that stay in touch. Particularly some very, very talented individuals whose counsel I treasure, and hopefully it's reciprocal. So there is some consistency there when we deal with new issues. But for the most part, there isn't a regular communication, line of communication.
There was an attempt a number of years ago to create a uniform law for regulation of continuing care communities. And the Uniform Laws Association had a panel, and it didn't seem to go anywhere. Were any of you involved in that? No? So it must have been even before Paul. Other questions in the audience? Let's go here, and then we'll come back over here.
This is a question for Bob Thompson. You were talking about long-term financial stability, and I would like to get your comment both under present California law and or is it, my question could have to be answered too in respect of possible updating, hopefully a future law. It's maybe not enough, I think, to talk about assuring long-term stability if the whole situation is not examined. A provider might have stability, but what is going to assure that that provider will apply its stability to provide both now and in the future for the CCRC? Do you have, under current law, the ability to test financial stability with respect to what will happen in the longer term future if that stability is not applied to the profit of the resident?
To repeat for the camera, or for the tape, the question really asked Bob Thompson to address the question of how can the department, or does the department, have the ability to assess long-term financial stability of the CCRCs?
Well, that's a difficult question. And while the statutes do speak in terms of long-term stability and that perspective, the mechanism available to the department and imposed on providers in terms of furnishing information to the department relates to their annual reports, which is basically predicated on their audited financial statements. So almost every aspect of the annual report is derived from the audited financials. Well, the audited financials are useful in terms of developing trend analysis, but again, it's all based on historical information. So the answer to your question is, we have to do what typical financial analysts do in assessing the value of an entity and its capability of sustaining that value. If you're going to invest in a company, it's one thing to know what it's worth right now. It's another thing to understand what it could be worth in the future. And if you buy shares of stock, you're looking to purchase future value, unless you're a value investor and somehow you think the price is understated. But for the most part, analysis entails estimating the ability of the entity to sustain its value and improve its value through growth or some other mechanism. That usually is, again, predicated on audited financials. So to the extent that kind of analysis can be performed, we do that. Could it be improved? Could the statute's perspective be improved? I believe they could, yes. And there are ways to do that. And I don't think that providers would be remiss or reluctant to do so, to comply with new requirements that would address the long-term aspects. There is, however, one element in the statutes that does furnish some guidance on the long term, and that's the Key Indicators Report. The Key Indicators Report represents key indicia of operating performance, financial standing, financial performance, and capital structure. And it looks back 5 years, and it looks forward 5 years. So on one sheet, you have basically a 10-year period that shows how these economic indicators or how these performance indicia are tracking. And in that regard, we do have the provider's representation as to how they believe the future will unfold for them financially. But there are other tools, and I would like to see the statutes amended in some ways to address that question.
By the way, one of the things that was raised earlier was the idea of an actuarial report being required of everyone. And part of the problem with that is that through an experience that I had with one of our clients, is that it doesn't really, the actuarial report process doesn't really work for all providers. And I think with the refundable entrance fee, or the repayable, I should say, entrance fee, where the repayment to the resident or the resident's estate is subject to the apartment having to be resold to a new resident, when an actuary looks at that, they cannot take into consideration the income that's going to come from the resale of that apartment. And so therefore, even if you would look at what might be considered, the most successful CCRCs in the state, you look at the actuarial report, and the actuarial report will say, that you cannot meet all of your obligations because actuaries, for whatever reasons, their own rules, are not allowed to look at the income from future transactions that haven't happened yet. And so does that mean that methodology, the repayable entrance fee, which by the way is much more common in other states than it is in California. I mean, this is the national standard is the 90%. Marriott really started it, I think, back in the late 80s. The 90% repayable entrance fee is something that is sort of a national phenomenon that's evolved over the last couple of decades, but it doesn't square with an actuarial report. And yet those same actuaries will say that, well, if we take off our actuarial hat and look at financial soundness of the organization, they'll give you an opinion that the community is financially sound.
Yeah, the piece that might not have come through there is that while the actuarial review contemplates the obligation owed to the resident on the termination of their contract, i.e. the repayment, the actuarial review does not contemplate the proceeds from the resale of the unit. So although there's offsetting revenue to the obligation, for purposes of the actuarial analysis, only the obligation is assessed. So that's what Paul's saying. It leads to basically an actuarial deficiency, which then the actuary will be quick to explain as not suggestive that the provider is in unsound financial condition. It's just that they don't meet the standards required for actuarial balance. So the actuarial study, though, it has its merits. I'm going to watch my time here.
You're fine.
Okay. In 2000, we hitched our horse to the actuarial study requirement. When I said every 10 years the statutes were comprehensively rewritten, and that was true. In 1990, I'm sure Paul had a leading role in that. In 2000, he did again, so did I. But we went in a direction that was entirely new for California. We discarded the old reserves requirement and decided that we would go with a three-pronged reserve system. We would require a reserve for operating expenses, for short-term liquidity. We would require a 12-month debt service reserve for midterm solvency. And we would require every provider to furnish the state of California a copy of an actuarial study showing their long-term actuarial soundness. So you had all three covered. And the only way we were really able to get that through the provider organization and the legislature was to say that we're going to do that on a trial basis, because we examined the actuarial study and its value quite closely and still had some reservations as to whether it would be effective in terms of either administering California's statutes or, on behalf of the providers, administering their facility. So we agreed to a 4-year trial basis for that requirement. And then we had another committee formed to review the results of that trial and determine whether or not the actuarial study requirement should be sustained. And the decision was not to sustain it. And the reason for that was that, notwithstanding the tremendous value of an actuarial study to providers so that they can fully understand their actuarial risk, it was of very limited value if it had to be made public. Because the critical nature of the actuarial review process was challenged if the provider had to make the results public. If the provider had to make the results public, obviously it wanted the actuarial balance to be as stable as possible with the greatest surplus possible. And because actuarial studies are so dependent on the assumptions, and there are innumerable assumptions involved, that because there are so many assumptions that the end result rests upon, those assumptions were manipulated so that the end result was the best possible for the provider, so that when the provider made the study public, they looked as good as they possibly could for marketing purposes. Well, we came to appreciate that very quickly. And I'm not going to go through the details of that, but I can tell you every single study filed by every single provider was closely reviewed by another actuary. And then we had a conference about it, and we determined whether it was reliable or not, and what its deficiencies were. And it became very apparent that once these things had to be made public, providers were not going to allow detrimental financial information to be circulated in public when they had to contend with a marketplace. Well, deferring to the value of those studies and recognizing that for those providers who had the greatest actuarial risk, we wanted to preserve that requirement, we simply reduced the actuarial study requirement to apply only to life care providers who have basically a level fee system, which then puts a great deal more actuarial risk on them over time, and really demands a great deal of their pricing structure and their estimation of the costs that they will incur for any given cohort of residents at their facility during their lifetimes. So we left the actuarial study requirement in place for those providers, but we removed the obligation to file those studies with the department and make them public. What we did instead was require that the life care providers who had an actuarial study requirement once every 5 years, they had to file the actuary's opinion as to their actuarial condition, and that is public. So even if a provider tweaks the assumptions so that they are actuarially sound and the actuary can render that opinion, they know, having gone through the process, under more demanding assumptions, what their real or what their actual actuarial position is. And that's what we sought to gain from this, that providers knew what their actuarial profile actually was, and that they filed with the Department of an accountant's or an actuary's opinion, so that we had verification that they'd actually conducted this study. And in place of the actuarial study requirement applicable to all providers, we devised the key indicator report, which I referenced earlier and which was raised in the first panel, which contains a tremendous volume of information that no provider can manipulate or dispute. It's derived right off of their audited financial statements. So
I'm going to pause there, and I hate to do this because we're at the core of some really important issues here. But we have a guest speaker for our lunch who can only be here because it's Assemblywoman Mariko Yamada, and they're in session. And so to make you continue to work, what we're going to do is have you go out and get your box lunch and come back in.